We will hear arguments in New York State Rifle and Pistol Association versus Brune. Counselors, please introduce yourselves.
Hello, my name is Grace Halleck, and this is my co-counsel, Anna Raffaelli. We're both from the Baldwin School, and we will be arguing on behalf of the respondent in this case. Mr. Chief Justice, and may it please the court, we contend that yes, the Second Amendment does allow the government to prohibit a law-abiding person from carrying handguns outside of the home for self-defense, and thus the New York law is constitutional and should be upheld. District of Columbia versus Heller established that the Second Amendment protects an individual right to keep and bear arms for self-defense, with the core of the right being defense of hearth and home. The amendment is not unlimited in its application. The court has long upheld concealed carry bans on the possession of firearms by felons and the mentally ill, laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, and conditions on the commercial sale of arms. The New York law does not substantially burden the core of the Second Amendment right because it only requires proper cause for concealed carry in public and does not burden the right to keep and bear arms in the home. The proper cause requirement for public concealed carry is an acceptable reflection of the longstanding and constitutional bans on concealed carry and carrying of firearms in sensitive public places. The New York law passes intermediate scrutiny. The government has an important interest in protecting public safety, and the law is closely related to this objective by creating specific measures to limit the number of firearms in public places. We ask that the law be found constitutional and upheld.
Thank you. Could you please provide a brief recitation of the facts?
Petitioners Robert Nash and Brendan Koch applied for a concealed carry license in September of 2014. Under New York law, all citizens wishing to keep or bear arms must apply for a license. The concealed carry license requirements are exhibiting good moral character, lacking a criminal or mental illness record, and there being no good cause for the license to be denied. To receive a license without regard to employment or place of possession, there also must be proper cause, which the state defines as, quote, special need for self-protection distinguishable from that of the general community or of persons engaged in the same profession. Nash and Koch were both denied concealed carry licenses on the grounds that they failed to demonstrate a special need and thus lacked a proper cause. Nash and Koch sued the superintendent of New York State Policy, Kevin P. Brune, and Justice Richard McNally. The question before the court today is whether the Second Amendment allows the government to prohibit a law-abiding person from carrying handguns outside of the home for self-defense.
Thank you. What does the Second Amendment protect?
The Second Amendment protects an individual but not unlimited right to keep and bear arms. DC versus Heller is the most relevant precedent in terms of interpreting the Second Amendment, and it affirmed that the Second Amendment guarantees, quote, the individual right to possess and carry weapons. And Heller did this through the important distinction that the Second Amendment's prefatory clause, which is a well-regulated militia being necessary to the security of a free state, does not limit the operative clause, the right of the people to keep and bear arms shall not be infringed, to only the context of a militia. However, it also made clear that, quote, we do not read the Second Amendment to protect the right of citizens to carry arms for any sort of confrontation. In other words, there are limitations and certain regulations that the government can impose on the ownership and carrying of firearms. Secondly, Heller also established the core of this Second Amendment right as, quote, the right of law-abiding, responsible citizens to use arms in defense of hearth and home. And this interpretation has been upheld by numerous lower court decisions, most prominently in Hightower versus Boston, which additionally cites United States versus Booker, United States versus Greeno, GeorgiaCarry.org Inc. versus Georgia, United States versus Barton, United States versus Staten, and United States versus Reese as other cases which affirm that the core of the Second Amendment is defense of the home.
Thank you. Why did the framers include the Second Amendment in the Bill of Rights?
Although the Second Amendment is now understood to codify an individual right to keep and bear arms, the framers created the amendment in the context of a national fear of standing armies and a military state. At the time of the founding, Each state regulated a militia consisting of every white male citizen from ages 16 to 60. The Constitution states the purpose of these militias as to, quote, to execute the laws of the Union, suppress insurrections, and repel invasions. When looking back at historical sources from before and during the framing, it becomes clear that a major concern, especially among anti-federalists, was that the federal government would disarm and neutralize these state militias and replace them with standing armies, which would then impose tyrannical military rule similar to the British occupation before the Revolutionary War. The Second Amendment was created in the context of these specific fears. However, it is not inextricably linked to this context. The right to keep and bear arms does not exist strictly in relation to state militias, but for the broader individual purpose of self-defense.
Thank you. What are the limits of the Second Amendment's protections?
When the government has a compelling or important interest, it can impose constitutional limitations on the right to keep and bear arms. And Heller lists examples of certain long-standing acceptable limitations, which are prohibitions on concealed weapons, possession of firearms by felons and the mentally ill, and carrying of firearms in sensitive places like schools and government buildings, as well as laws imposing conditions on the commercial sale of arms.
Thank you. What weapons does the term arms include?
The term arms is not a historical term of specificity, and therefore is not limited to only weapons present at the founding or weapons used in state-regulated militias. Heller affirms this, defining arms as, quote, all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. However, the term arms is not all-encompassing either. Heller emphasizes that the right was not a right to keep and carry any weapon whatsoever, but rather protects weapons in, quote, in common use by citizens for lawful purposes like self-defense. Therefore, bans on assault weapons, machine guns, and large capacity magazines are constitutional and have been upheld in cases such as NYSRPA Inc. versus Cuomo and Friedman versus City of Highland Park.
Thank you. What is the difference, if any, between the verbs keep and bear?
Heller defines keep in the context of the Second Amendment as a general term meaning to possess or have arms, and not a specific term only referring to the militia or military related activity. And similarly, bear is a general term meaning to carry for the purpose of offensive or defensive action, and also does not have a militia related connotation. So in that sense, keep and bear are just general terms meaning to possess and have arms and to carry arms, respectively.
Thank you. What is a militia, and why did the framers refer to it in the Second Amendment?
As briefly explained previously, at the time of the founding, each state regulated a militia consisting of every white male citizen from ages 16 to 60. These militias were formed, quote, to execute the laws of the Union, suppress insurrections, and repel invasions. The fact that they were people's militias and composed of most American citizens rather than being a separate occupying force made it an alternative to a standing army, which was viewed as a tyrannical and oppressive threat to democratic government. The framers referred to militias in the Second Amendment because at the time of the founding, the biggest concern surrounding firearms was that the federal government would disarm the militia and replace it with a standing army or military rule. Thus, the prefatory clause, quote, a well-regulated militia being necessary to the security of a free state, is a statement of purpose and reflects the major historical issues at the time.
Thank you. How should courts determine if a gun control regulation is considered long-standing?
When considering gun control regulations, Heller provides a list of provisions it considers long-standing, which are, as previously mentioned, the ban on possession of firearms by felons and mentally ill, the ban on carry in sensitive places, and conditions on the commercial sale of arms. And it also implies that bans on concealed carry fall into this category. And although Heller does not provide further insight into why these prohibitions have been granted long-standing status, it is unlikely that they are based on originalist reasoning, which would be to say that they are long-standing because they were understood to be justified at the time of the founding. And this is simply because historical sources from the founding do not sufficiently support these exceptions. And in fact, the prohibitions have only existed since the early 20th century, which is much later than the time of the founding. Therefore, whether a provision is long-standing is not dependent on if it dates back to the founding or not. Rather, the whole tradition and history of our country is considered. And this argument was laid out by Carlton F.W. Lawson in his article, Four Exceptions in Search of a Theory. And Lawson goes on to argue that the court's reasoning was instead based on some form of scrutiny, which all of the exceptions pass under. And this level of scrutiny is most likely intermediate, since all of the exceptions fail under strict scrutiny and rational basis review was ruled out by Heller when considering the Second Amendment.
Thank you. What is strict scrutiny, intermediate scrutiny, and rational basis review?
Strict scrutiny, intermediate scrutiny, and rational basis review are tests applied to challenge laws to determine their constitutionality. Strict scrutiny has two requirements that must be met in order for a law to be constitutional. First, the government must be pursuing a compelling interest. Second, the means used must be narrowly tailored to achieve this interest. Under intermediate scrutiny, the government must be pursuing an important interest, and the means used must be closely related to the interest. In rational basis review, the government must be pursuing a legitimate objective, and the means used must be rationally related to the objective.
Thank you. Is there a difference between openly carrying a firearm and concealed carrying a firearm?
Yes. In fact, there is a long-standing history of restrictions on concealed carry of firearms and not open carry of firearms. And this court acknowledged this in DC versus Heller, which states, quote, "Like most rights, the Second Amendment right is not unlimited. It is not a right to keep and carry any weapon whatsoever in any manner whatsoever for whatever purpose. For example, concealed weapons prohibitions have been upheld under the amendment or state analogs." So Heller places prohibitions on concealed weapons in the same category as felon and mentally ill bans, sensitive place carry bans, and commercial sale of arms regulations, all of which are established to be constitutional, long-standing limitations of the Second Amendment. Heller cites a number of cases from the early 19th century that upheld bans on concealed carry of firearms to support this. Examples include Amet versus State, State versus Chandler, State versus Reed, Robertson versus Baldwin, and Nunn versus State. And lower court cases have ruled consistently with Heller's interpretation of the Second Amendment and reestablished the longstanding and constitutional nature of concealed carry bans. And examples of these include Peruta versus County of San Diego, Hightower versus City of Boston, and Peterson versus Martinez.
Thank you. How should the court consider the public safety implications of licenses to carry firearms?
Well, the court should place extreme weight on the public safety implications of firearm licenses. With gun violence increasing nationally in recent years, making clear rulings on the constitutional limits and rules of gun control is essential in preserving the right granted by the Second Amendment without needlessly endangering the general public. Although the right to keep and bear arms is important and enshrined in the Constitution, the government interest in reducing gun violence by limiting the amount of guns in public, sensitive places, is equally as essential a duty in protecting the American citizen.
Thank you. And how would you have the court rule today?
We ask that the court rule that this New York law is constitutional and uphold it.
Thank you. Thus concludes oral arguments.